for joining us for today's special edition of 3 Healthcare Headlines You Need to Know from Tallahassee. We're extremely pleased to have the opportunity to come to you today with some breaking information that we've had at a federal level this week with an announcement from the Federal Trade Commission related to non-compete clauses. So it's a little different than the normal 3 headlines from Tallahassee, but this was an issue we talked about during the Tallahassee legislative session this year, just because non-competes and restrictive covenants was on the agenda for discussion in Tallahassee. But now the feds have stepped in and issued a rule. Joe and I figured we better come back to you guys with an update on this issue, and hopefully we can provide some value as we're all just getting our arms around what this ruling means for physicians in our community moving forward. So again, my name is Fraser Cobbe. I'm the executive director of a number of medical associations here in the state of Florida. This is our platform for us to deliver breaking news to our members, so you stay in touch on things you need to be aware of as you continue to practice and serve your patients. I'm joined again today by my partner in crime, Joe, who's going to introduce himself and then start introducing our special guest for today's segment.
Good to see you, Fraser. We took a little bit of break after the legislative session ended, but when little things like this, big things like this pop up, we need to, record a video and kind of let everyone know what's going on. So again, I'm Joe Daraskevich. I work alongside Fraser at several medical associations, societies across the state of Florida. And today I do have the pleasure of introducing one of our special guests, Meg Heiden of Smith, Hulsey, and Busey. Meg is an experienced advisor and litigator working in the firm's healthcare, labor and employment, and litigation practice areas. For more than a decade, she has supported clients in managing a broad range of complex legal issues in employment and healthcare matters. Her bio goes on for a little bit longer than that, but trust me, she's got the qualifications. Meg, thank you for joining us today.
Thank you.
And I have the pleasure of introducing our other guest today, because we weren't going to just put Meg on the hot seat. We decided to put Ben on the hot seat as well. So we have another attorney that's joining us today, another special guest, Ben Mirza, who is the managing partner of Mirza Healthcare Law Partners, which is a firm that offers legal services in the area of healthcare business, compliance, and litigation. Ben is actually a former CPA turned attorney with over 20 years of experience, and his practical and numbers oriented, and he works exclusively in the healthcare space on healthcare transactions and serves as counsel for a number of medical associations in the state, including Broward, Lee, and Dade County, and serves on the Florida Board of Dentistry as well. So thank you, both of you, for joining us for today's issue. And I think, Joe, I tagged you with asking the first question.
I can take that. So let's get started. We'll jump right in and cover this topic as much as we can. Obviously, a lot's happening this week, and we'll be filling you in as developments happen over the next months and weeks to come. But this week, the Federal Trade Commission announced a long-anticipated rule that seemingly bans non-compete clauses in general in all sectors of the U.S. economy. Meg, at a very high level, can you summarize what the rule does, and are physicians treated any differently in this rule than other sectors of the economy?
So you've pretty much summed it up very well, because the effect of the rule is simple and broad. The way they define the terms is very broad. So any entity, which is any kind of corporation at all, the rule covers any kind of worker, whether they're an employee, an independent contractor, even an unpaid volunteer, an intern. If they're doing work, that is covered under the rule. It has a very broad definition of what a non-compete clause is. It's any term or condition of employment that prohibits a worker from or penalizes a worker for being able to work or own a business or do various things after the worker's employment ends. And they added some language between the notice of proposed rulemaking that we had in January of 23 and this final rule more than a year later. They added some language to that definition so that it also includes as a non-compete anything that functions to prevent a worker from having future employment after the employment ends. And the reason that's important is that they say in their very long 500+ page commentary, they're trying to get non-solicitation agreements, non-disclosure agreements, and tuition or training repayment agreements that are overly broad or that are broad enough to impair the worker's ability to go out and get a new job after their employment ends. And so basically what they do is they say across the board, all of these non-competes are illegal. They're an unfair method of competition. That's what the Federal Trade Commission says it has the right to regulate. Of course, that's up for debate, and we'll talk about that. But they say it's an unfair method of competition to create or request an employee enter a non-compete, to enforce a non-compete, or to tell a worker that they're subject to one. There is a limited exception for enforcement of non-competes with senior executives. They've set a very high bar for that. And they've actually required, by the effective date, employers have to give clear and conspicuous written notice to all their employees who have signed agreements with non-compete provisions. They have to give written notice that we're not going to enforce this. It's no longer effective. And the FTC has provided a model form of notice for employers to use there. There are a few exceptions: bona fide sale of a business. If there's an existing cause of action, meaning that they already have the right to sue a former employee for violating an agreement, that's not affected. And then if there's a good faith belief that the rule doesn't apply, then the employer would not be subject to penalty.
Okay. Yeah, Ben, anything to add to that? That was a pretty thorough breakdown, though. Thank you very much, Meg.
That really was. Yeah, one of the things that I think Meg pointed out is that that this includes contractors and interns. That's worth noting, because employers can't, large employers can't just simply turn employees into contractors and get away with it. This rule will apply to everyone, including contractors and interns. So I think that was a really really interesting point, and it's going to carry a lot of weight. It's going to upend the industry, at least in healthcare space. A lot of contracts are going to turn upside down. As you know, healthcare has got a lot of non-competes. So.
Fantastic.
And the other, sorry, Fraser. The other point that I think is really important, you asked if there's doctors are treated differently under this new rule. And that's a really interesting question, because the Federal Trade Commission has traditionally acknowledged that it doesn't have the right to regulate not-for-profit entities. That's an argument that relates to the 1914 Federal Trade Commission Act and the way it defines corporations as entities that are existing to obtain profits. And so there was a lot of talk after the notice of proposed rulemaking about what a mess this was going to create in the healthcare sector if for-profit entities are not allowed to have non-competes and not-for-profit entities are allowed to have non-competes, because this rule would not apply to them. And so the FTC, in the 500 plus page comments with this rule, said, look, we know there's this issue out there that we're not allowed to regulate not-for-profits, but we don't concede, we the FTC do not concede that an entity is a nonprofit just because the IRS has agreed that they're a nonprofit subject to 501c3. So instead, the FTC says they're going to apply a two-part test to determine whether a nonprofit is truly a nonprofit that wouldn't be subject to the FTC's regulation. And of course, we can all probably guess how the FTC is going to interpret those tests in the context of health systems.
Fantastic. Thanks for that additional point, Meg. Ben, a follow-up on something that Meg mentioned in her summary. The rule does differentiate between different classes of employees, seemingly enabling non-competes to still apply to executives while removing them for non-executives or all others. Can you talk a little bit about what sort of tests they've discussed or what differentiation there will be between the two classes of covered employees? And can you elaborate some thoughts on what that may mean in the healthcare sector, in particular for physicians and physician executives?
Yeah, so the rule basically differentiates between senior executives and regular staffers, right? When it comes to the physician world, you're going to have physicians that are regular physicians, and then you're going to have senior executive physicians that are in some sort of a decision-making capacity. So one of the thresholds that's out there is $151,164. So the person has to be making at least that amount of money, which most physicians are. I think, unless if they're part-time, and I'm not sure exactly how that'll play into it, but most full-time physicians do clear that first threshold, the 151,000. The second part of it is, in order to actually be subject to the non-competes, the executive has to have some sort of significant decision-making authority. They have to take a role in like strategic planning of the organization, and they have to have some level of managerial duties, meaning like they've got to oversee a staff of some level of some relevance. And I think that's how they actually differentiate of what is a regular staffer physician versus a senior executive. It's really that strategic decision making. Are you overseeing other positions? And so that's the summary to that. But yeah.
Yeah, it's interesting, Ben. And what comes to mind immediately is like in a hospital healthcare setting, it would be easy. That line is a little easier than maybe in a private practice setting where you've got physician partners that may be involved in strategic planning and doing all that too. So I know you don't have the answers as we're all coming to grips with this, but just an interesting thought that popped into my mind immediately is that line may be a little blurred in a community, physician practice setting.
I know that's a really good point. Like, let's say if I'm a generalist and you're a cardiologist and we're a part of the same practice, tomorrow we decide, hey, how are we going to expand our cardiology program? You would be like, you as a cardiologist would be the natural person to help partake in that decision-making process, right? So,
that's interesting.
Yeah, I could see that being an issue.
Well, and the next topic I want to bring up today, or Megan, anything to add to that as well?
Yeah, I think there's just one important distinction or clarification to make on the senior executive carve-out. It's only a carve-out for existing agreements. So what it says is that employers who have these agreements, these non-compete agreements with senior executives already in place, will have the right to enforce those in the future, but they will not be allowed to enter into new agreements after the rule takes effect, regardless of whether the person meets that senior executive criteria or not.
That's a great point, Meg. I'm glad you pointed that out as well. Anything else to add, Ben, before we move on?
No, that's it. That's it.
All right. Well, Meg, the next thing I wanted to bring up, we all live and work in the state of Florida. This is obviously a federal rule that has been passed. Is there anything in Florida law that will impact or limit implementation of this specific rule?
No, and actually it's the other way around. So this is federal federal regulatory activity coming out of a federal agency. And so we know state law or federal law trumps state law. And we actually have an express preemption here in this rule. So it says very clearly that the rule intends to overrule any state statutes that are more permissive in terms of allowing non-competes, but it does not intend to overrule any state statutes that are more restrictive. So if you were in a state like California that had an even more restrictive non-compete law, that state statute would remain in effect. But a state like Florida that has a statute allowing a lot of non-competes, that statute is going to be essentially overruled by this regulation.
Great point. Great point. Ben, anything to add to that?
Yeah, I mean, I think as far as this rule goes, I do expect a lot of challenges to be made to it. I think it's just upending a lot of industries, whether you look at the technology side or the healthcare side. So this states perhaps litigating their laws against like what Meg had said, the federal preemption is the supreme law of the land. However, I think the states do have a right to actually challenge it. I'm not a constitutional law guy, but at the end of the day, I can see somewhere along the way the industry or the states challenging it. So, yep.
And that kind of leads us into like a timeline for implementation. And I know the rule does establish implementation timelines, but well, that's pretty cut and dry. I mean, what advice would you have, Ben, for physicians currently at this moment, kind of coming to grips with this rule again, and what should they be thinking about in the coming days and weeks?
So the effective date of this is supposed to be 120 days after it's published into the Federal Register. So far, and we just looked this up just before the podcast, this has not been published in the Federal Register. Now, if you calculate out 120 days from, I guess a couple of days ago, it would be August 21st. So if this is to go into effect, let's say it comes out 3 days later, maybe like August 24th or August 25th, something like that is probably when this will go into effect. So yeah, that's the timeline I see on my horizon.
So obviously we'll be updating people as developments come, and as we kind of get closer to that date, we'll have a little more information. This is again a very surface level look at what we had happen this week. Moving on to a question I have for Meg, from a management standpoint for practices or hospital or health system leadership, what are you advising your clients in terms of existing contracts with physician staff members and physician executives?
As of right now, the only advice is like put your head between your knees and take some deep breaths. There is, as Ben mentioned, a lot of uncertainty about this. A lot of very smart legal scholars are publishing very elaborate articles explaining all the ways that this action by the FTC is questionable. It's unprecedented. Anytime an agency takes a giant step into unprecedented territory, there's going to be a lot of litigation over generally, does the FTC have authority to do this at all? There's going to be litigation over that nonprofit piece. There's going to be litigation over whether the FTC followed the right process in getting this rule put into place at all. So everything in terms of when it will go into effect, will it even become enforceable, or is a court going to enter an injunction while all of this is litigated? Those questions are all hanging up in the air, and I suspect we're going to see a lot of activity very quickly when the rule is formally published, and then we'll have more to go on in terms of what advice to give people. So for now, I think don't do anything differently, just keep doing what you're doing and plan to revisit this in 2 or 3 weeks to see where everything stands then. And I would say if anyone is interested in really looking into the different arguments about whether this is enforceable, one of the federal trade commissioners named Christine Wilson wrote a dissenting statement in January 2023 when the notice of proposed rulemaking came out, and she laid out all of those arguments that we'll be hearing more about. So if anyone really wants to dig into those details, that would be a good source.
Well, in that wait and see approach too, everyone sees the headlines and, they're kind of jumping at the, a chance to do something, but this is kind of the time to kind of let it settle in and wait for more details to come out. So that's good advice. You put your head between your legs and just kind of wait for everything to kind of clear out a little bit, and then we'll have more information. So Fraser, any other thoughts on that, or Ben?
Yeah, I think once once it passes all of these challenges, which I'm not so sure it necessarily will, just because there are going to be a lot of challenges. Once it's challenged, it'll go to court. They'll probably ask for a stay order, meaning that the side that's challenging this rule is going to ask the court to stay the ruling of it, so it's not enforced against any company, any entities. And that stay will probably be in place for a while till this clears a courtroom. So don't be surprised if this rule does not take effect till for a while. I mean, it could be 6 months, it could be a couple of years. But it's out there. Everybody's going to be grappling with it, and Megan probably has more experience in this area than I do, which is the challenging of such a thing. So.
Yeah, I appreciate those comments. And I was going to ask you both a very unfair question to kind of put into context the meaning of this ruling at this time and where we are in healthcare, and just some thoughts on the long-term impact this may have, given all the challenges. Again, it may be unfair that what ultimately gets implemented may be different from this rule, or it may look exactly like it. But I mean, given the number of physicians that are now employed, 70+%, depending on what reporters say you look at, I mean, the potential ramifications of this are huge. So I don't know if either of you want to opine a little bit kind of at a very high level where we are with the kind of historic relevance of the ruling coming out this week.
From my perspective, and I'd love to hear Ben's because I know he's more in the transactional sector, But I think the biggest concern that we've heard from everyone is that this is going to dry up investment dollars in healthcare industries. That if a group cannot purchase a practice with the expectation that that the physicians employed by that practice will stay employed versus going out immediately to set up a competing practice across the street, it's hard for them to know what value they're getting in exchange for that purchase. And so I think potentially we're looking at a major sea shift in how the healthcare industry is evolving.
Yeah, and I think it's going to actually require the businesses to get really creative about how they compensate the, strategic individuals that they're recruiting. And one of the things, and I didn't see much on this, is what if you give stock to an employee? Can you bind them under a stockholder or a shareholder agreement versus an employment agreement? What is it? What was its intended purpose? What sort of shares of stock are they? Are they the actual real voting common stock? Are they going to be the phantom stock shares? People will probably get creative with how they structure transactions in this space to try to figure out how they'll get, and tie down senior executives. So.
That's a great point. And obviously there, only time will tell exactly what this is going to look like when it's all said and done. But I felt like this was a good conversation to get everybody together and kind of just talk about everything in the initial phase. And we can obviously break this down further once we get down the road a little bit. But Fraser, any thoughts, any last thoughts before we wrap up this edition?
No, just a huge thank you to Meg and Ben. We put you on the spot asking you to digest a very large ruling in just 48 hours or so. But we appreciate all the wisdom that you've shared with us today, and taking your time and giving our members, at least a quick summary of what to expect this ruling may do, and how it may impact, what they do on a day-to-day basis. So just a huge thank you to you both for being here, and thanks to Joe for helping co-host today.
Thanks, guys. We really appreciate it, and we'll be in touch anytime anything like this pops up again, and hopefully we can all get together and break it down for the physicians across the state.
And I should say,
Sounds great.
And I should say, for any of the physicians listening today, or administrators, of course, if you have any questions, definitely follow up with Meg and Ben. Obviously, they're a wealth of information. They'll learn more over the coming days, and certainly use them as a reference. We appreciate their support of our organizations, and again, for joining us today.
Thank you.